So the topic that I was very keen to speak to all of you about, specifically related to this question of child participation, right? And I'm given to understand that some of you already submitted papers, right? That you will be presenting later today, and then eventually there's an award as well. So good luck with that. But before I begin, I just want to get a sense of what are some of the topics that some of you have already written about. So if you can just very briefly get up, tell me your name, and just very briefly tell me what area of child. Yeah. Anyone can start.
My name is Kaustubh, and I have written my paper on right to education.
Okay, perfect. Nice. Anyone else? Yeah.
My name is Akshara and my paper is based on AI and AI generated exploitative content on
Child sexual abuse material? Okay, alright.
My topic is on deepfakes and the psychological impact on children due to the deepfakes.
Okay, interesting.
My name is Bharat and I have written the topic on the cybercrimes related to children.
Cybercrimes just general, right? Yeah.
Hi, so my name is Rudrakshi and I wrote the paper on children with disabilities.
Okay, interesting. Anyone else? Yeah.
My name is Malik. I have written on juvenile delinquency.
Very interesting. Okay. Yeah. Are we missing anybody, or is that? Yeah.
So I'm not exactly focusing on a particular right. I'm just saying where's the gap between the rights and the implementation part. Why
Okay,
are
so
they not
focusing
being
on
enforced?
right. So focusing on implementation. Are there specific rights that you dealt with while looking at implementation?
Yes, I'm looking at specific right. What law is there and how is it impacting currently the society and where is the gap? Why is still it is not?
A gap analysis.
Yes.
Perfect. Right. Anyone else that we've not heard from yet? This, yeah, I think I saw someone's hand in the back.
My topic is on child trafficking on a research which I have done.
Child trafficking in Bangalore? Okay. Yeah, someone else, yeah.
My topic is on extending the education right from beyond 14 years to 18 years on impartial justice education right till 15.
Okay, very interesting. Yeah, because one of the limitations of the Right to Education Act is that it is effectively restricted to primary education. It doesn't really consider secondary education, senior secondary education. But it is interesting because that's where the law gets tricky, right? The Samagra Shiksha Abhiyan scheme, which used to be the Sarva Shiksha Abhiyan scheme, now it includes a teacher training component. It basically amalgamates multiple schemes into one. That does cover secondary education as well, right? That covers education technically all the way up until the age of 18. But because the Right to Education Act, which is a statutory codification pursuant to the Unni Krishnan judgment, which I'm sure many of you might have already come across in your classes, right, which was an extremely important precedent because it was one of the first times that you essentially saw the Supreme Court read an unenumerated right into the right to life, right? So it wasn't a separate right, it was just read into the right to life, and then you've got Article 21A, and then you have, of course, the Right to Education Act. But then the question is, if the constitutional right only exists up until, say, the age of 14 years, but it's not strictly 14, it can be in an instance of, say, a child who's been rescued, right, who's then been integrated into a school. It can be basically up until you finish the 8th grade. So you can cross 14, but the stipulation is typically 14 or the 8th grade. That's typically where the right ends. So then what happens to everyone else who's at the mercy of the Samagra Shiksha Abhiyan scheme, but doesn't necessarily have the protections offered by this right? So these are pretty interesting questions. It's quite interesting. I just wanted to get a sense because I was wondering which parts of my presentation might be relevant to you all. I will be looking at two examples to deal with this question of participation. Both of them will be relevant to some of what you have written. One of them is the Juvenile Justice Act, and I'll look at parts of the Juvenile Justice Act that deal with participation. There are many parts of the Act, and it's important because some of you may know, some of you may not, but the Juvenile Justice Act is the nodal child-related legislation in India, right? Every single other act, special act like the Protection of Children from Sexual Offences Act, or the Child Marriage Act, or the Child Labour Prohibition Regulation Act, any of these laws ultimately are in some way tied to the judicial administration or the basically the adjudication and the apparatus that's available under the Juvenile Justice Act. Right, and it ranges from everything to children, from children in conflict to the law, to adoption, to various contexts of children in need of care and protection and so on. So I'll speak a little about what the law says, but what some of the gaps are, right, to take from what one of your papers is about. What some of the gaps are, what some of the challenges are, and how do you negotiate participation when participation isn't the only value, right? And I'll come to that in a bit. I'll also speak about the POCSO Act because that's also an interesting area to talk about when we speak about participation, because there are challenges, right? How do you factor in participation in a law that's technically rooted in an idea of protection? And protection and participation don't always necessarily go along with each other. They can sometimes be in tension with each other, right? There's this other imperative, and I'll discuss that also, on the principle of the best interest, right? And you, in your research, for those of you who did a bit of research on child rights generally, you would have come across this phrase, the child's best interest, 100 or 1,000 times, right? It's repeated over and over again that it's almost impossible to forget. But if I just, we don't have the time for it, but hypothetically, if I just look around this room and ask everyone to tell me what your idea of a child's best interest is, and I gave all of you the same example, there is absolutely no situation in which every single person in this room will have the same answer. So it is effectively, the question then is it a manageable standard? It's easy to say that I did so and so action as a child-related stakeholder in the child's best interest, but I can justify about anything to say that it's in the child's best interest. What actually is in the child's best interest? We'll discuss participation to understand that a little more, right? And can you really have a situation where any decision is in the child's best interest if you don't bother hearing from the child, right? So very briefly, this is some of the loose objectives in terms of what I want to speak to you all about today. I may go off script a little bit depending on our discussions, but that's fine. This is just broadly supposed to give us a framework. Right? First and foremost, it is to set up some kind of context and provide a perspective on the children's right to be heard, which is basically the right to participation. It's interesting, under the United Nations Convention on the Rights of the Child, the language used isn't participation. The provision, particularly specifically Article 12, speaks about the right to be heard. And that has now been expanded by the Committee on the Rights of the Child and multiple sort of jurisprudence from the committee to say that it includes participation more broadly. And if you read the provision, it does lend itself to a broad interpretation. It's not a narrow or restrictive provision by any standard, right? To problematize the scope of this right in relation to the children's best interest and protection. Honorable Justice, I think today when he was speaking about some of the, he spoke at length about many issues related to child rights. And if you paid close attention to what he was saying, you would have heard some of these areas where there's potentially a tension between what children have the right to in terms of participation, and participation is ultimately what? The freedom and opportunity to say things I want, to do things I want, that don't, of course, cause harm or in some way violate the law, right? To basically operate with some amount of autonomy in my life. And when you speak about participation, participation is maybe one facet of that autonomy. Participation in regards to judicial proceedings that concern me. That's within the scope of the right to participation. But there are other aspects of participation that could include a broader context. For example, the right to freedom of expression under Article 13 of the United Nations Convention on the Right of the Child also has a participatory element, but that looks at more of a public context when you look at participation. That isn't restricted to matters concerning the child. That includes just about anything. A child at a movement, a child in a protest, whatever the context, right? A child who has an issue with school policy, it could be anything, right? So there are various contexts in which you have this participatory potential under the convention, but you also have situations where the child's best interests may sometimes not be in line with their participation, right? And how do you then negotiate this? Is one child rights imperative or value more valuable than, say, another? If you do have to balance two rights or principles that are in tension with each other, how would you balance them? And who gets to make the decision to balance them? Is it an adult who has their adult-centric interests in mind, are we bothering to listen to the child when we make decisions that affect their lives immensely? Or do we just get to decide whatever's in the child's best interest, and the child's only obligation is to keep quiet, listen, and then progress along with it, right? These are questions that you ask, and these questions become very important when you consider some of the most challenging areas of the law. How many of you have taken already completed your jurisprudence course or done a little bit of legal philosophy? Show of hands. Okay, that's a good chunk in the room, right? Have some of you all or all of you come across this Hart-Dworkin debate? Have you read a little bit about Hart-Dworkin? I see one person nodding. Anyone else? It's fine if you haven't. Okay, yeah. A couple of you have seen it, right? So I'm oversimplifying. Some of you may not appreciate this, but effectively, because we have constraints of time, the essential debate is that Hart recognizes that the law is not elastic, right? That the law is relatively inelastic, and that in certain hard cases, the law breaks down. The law cannot operate there. And Dworkin's understanding is that no, even in situations where the law seemingly doesn't apply, there are certain principles, natural principles, or whatever you want to call them, that technically do guide judicial discretion. Now, that's an interesting way to look at it. But ultimately, if the idea is that the law doesn't apply in some of these hard cases, the question is, are there really principles guiding action, or is it just somebody exercising their own discretion on the basis of what they think is most appropriate? Right? That's really at the heart of the question. Now, where does this question become important? Where do you think are some of the hardest cases, according to Hart's definition, the hardest cases where the law struggles to apply in child rights, where you feel like children's participation is difficult to maintain because the law has a more protectionist view, or the law believes that this is not what children should be doing, right? Any areas that come to mind immediately, just think of children's issues, adolescents issues, any area where you feel like it's hard to make a point about children's agency because there's a protection concern as well. Anyone, any ideas?
Custody issues.
Yeah, absolutely. Can you speak a little more about that?
How can we expect the child to know which of the parents, if he or she is supposed to choose which of the parents is supposed to reside with for the rest of his life when there is a divorce, or for whatever reason? How are we supposed to expect the child to make the right decision? Or because there can be manipulation.
I'm from, which works in the space of child protection, child and law, and child justice more broadly. We engage with child protection, judicial stakeholders, basically anyone who's really working with children. One of the things that we are slowly moving towards is to do research with children and childcare institutions who come into conflict with the law because of POCSO offences in a consensual relationship. Right? So we are going to look at that and try to understand this from an adolescent's perspective, because the issue is again not simple, and this is where we go back to the ultimate tussle between protection, best interest and participation. Because let me give you an example, right? If we're speaking about a 18-year-old just reached age of majority and a 16-year-old, right? And it is, from the facts and circumstances available, a consensual case. That's one possibility. Let's say we're dealing with a 17-year-old and a 12-year-old, right? The 12-year-old is telling you that it is a consensual case, but you perhaps have some doubts. Let's say you're dealing with a case where it is a 17-year-old and a 27-year-old. Now the 17-year-old will absolutely lobby you, if you are the judicial officer, to say that this is consensual. You have cases where people threaten self-harm before the court if bail is not given, right? I think His Lordship also briefly mentioned that people can come with very emotional arguments, and they do often happen in bail hearings in consensual cases, quote-unquote consensual cases. But if it is indeed a 17-year-old and a 27-year-old, the question is that really consent? Would that constitute informed consent? Because the interest you're protecting there is not just the child's right to participate now, but the child's right to have their best interest be a primary consideration 10 years down the line. Because what happens if if you say this is a consensual case now, and that 17-year-old 10 years down the line when they're 27, comes to you as a judicial officer and says, I can't believe you allowed that. I was 17, I didn't know any better, you should have stepped in to protect me. how is the state then supposed to contend with that? So consent is not an easy case. It's not an easy context to deal with. Not every case that is seemingly consent is actually consent. Some of you may have engaged, if you've done research on POCSO and sexual offences, you would have come across this term manufactured consent, right? Manufactured consent vis-a-vis informed consent. If you have a 12-year-old who tells you that, he has a favorite uncle. His favorite uncle likes to play special games with him, right? His favorite uncle is really cool. His favorite uncle talks to him about things that no other adult talks to. The nature of his relationship is a friendship. Is that of a friend with this uncle. But this uncle also plays games or, just happens to be more affectionate than he is used to, and he doesn't like it. And in this 12-year-old's mind, he is given to understand that every single uncle who really likes their nephew does something like this. This is just an expression of his love and affection. And apart from this uncomfortable act, the 12-year-old genuinely has a relationship that's rooted in love and affection with that uncle. In every other context of that child's life, the uncle is amazing. And so the child is also contending with the fact that there's this one interaction that I don't like, but in every other context, this person's really great. So how can I ever do something to betray their trust? How can I ever report them? How can I ever get them into any kind of trouble? Now that is classic. I described to you essentially what is classic grooming, right? Now grooming also will present itself as consent, but is that really consent? If a person doesn't understand that sexual activity is not a normative part of a healthy uncle-nephew relationship, do they have the capacity for informed consent? If they don't know what some of the health consequences are from unprotected sexual activity, can you give informed consent? Right? If you don't know what some of the health consequences are in terms of sexually transmitted infections and so on, can you give informed consent? These are multiple areas of consent that we typically look at to say that, okay, this person can give informed consent, that person can't. So there are all these complexities. This isn't to say that adolescents can't have the capacity to consent. They absolutely can. And every bit of scientific literature across the world demonstrably proves that adolescents, in certain circumstances, right, where they are provided sex education at the correct period of time through their schooling, where they are provided a supportive, nurturing environment within the context of the family, that they can engage in normative and healthy sexual behaviors. But it is within certain conditions. So the context of that, what does the law really mean to the child, right? I was at a conference, we did a review consultation in 2022 on POCSO because it had been 10 years. It had come in 2012, it had been 10 years, so we did a review consultation. And we did the consultation at the National Judicial Academy. And we had many judges from various honorable high courts present there. And one of the honorable high court judges asked a very simple question. He said, if POCSO existed when we were in school or college, at least 50% of the room laughed. So at some level, there is also recognition at the highest possible level that there are issues in the law. But again, we come back to this point about how do you reconcile protection and participation, because every case presents a different challenge. I don't know, there are no easy answers to that. The answer perhaps is that we need to speak to children and we need to approach the problem from multiple perspectives. Clearly approaching the problem from just a legal perspective is insufficient. So then, can we borrow from other disciplines? Can mental health tell me anything about adolescents' capacity for consent? It can, right? Can trauma tell me anything about the consequences of grooming? It absolutely can. What are the different domains that I can borrow information from as, say, a legal practitioner to get an understanding of adolescents' capacity to consent and to help devise, say, an assessment methodology or a framework to differentiate cases of consent, informed consent from either manufactured consent or grooming or abuse or exploitation, so on and so forth. Right? Now these discussions at some level may seem irrelevant because we have a law that criminalizes all sexual behavior below the age of 18, but that law can change over time, and it will. Right? I don't know if many of you are aware, but recently the Law Commission of India actually in one of its reports had taken up the issue of adolescent consent And they didn't ask for there to be a lowering of the age of sexual consent. But what they did ask for is to remove the mandatory minimum sentences, which are very high under the POCSO Act, to give more room for judicial discretion and to process the quote-unquote offenders through the juvenile justice system. So the Law Commission's recommendations is that in consensual cases, you process typically the adolescent boy through the juvenile justice system. To what degree would that still meet the child's right to participation, agency, autonomy? I don't know. That's something for you to decide, right? Now, what does justice mean to a child? Justice is a really complicated word. I can't remember when I fully learned this concept, but I'm pretty sure it wasn't in middle school or something of the sort. It is not an easy word. Just like abuse isn't an easy word. They're both concept words. So they convey pretty important concepts in the way the word is constructed, right? And justice can mean any number of things. A child could take a very Rawlsian approach to it and say justice is fairness. That something I think is fair is just, something I don't think is fair is just not just, right? Children, especially very young children, typically are more egocentric than others, and therefore will base their ideas of what is just and what is fair on the basis of what most fundamentally relates to them, right? That may be one view of justice. For an adolescent, justice may mean something else. For an adolescent who comes from a different context, justice may mean something else, right? But if I can just go around the room and take a few responses. If you had to put yourself in the shoe of, a child of any age group that you so choose, how would you view justice? What would justice mean to you? Especially say, let me clarify this example. Say you're a child who's come into conflict with the law, right? It's not for a serious offense. You stole something, you tried to basically steal something from a store, and then you ran away and then you got caught. Juvenile Justice Act, for example, under Section 15, which came in 2015, no surprises in terms of where or why that came from, I'm sure already all of you know, came after the Nirbhaya case, right, where there was a juvenile involved. And so the 2000 Juvenile Justice Act was a completely restorative, reformatory, absolutely no punitive orientation in the 2000 Juvenile Justice Act. The 2015 Juvenile Justice Act also largely rehabilitative, largely restorative, but has one component which is the provision for juvenile transfer, for preliminary assessment and transfer to the criminal justice system. That came because there was public pressure in the wake of Nirbhaya, and people felt that adolescents or juveniles got away scot-free, got away easy. We come back to the issue of competing social interests, right? And in the wake of that kind of pressure, governments typically concede and pass stricter laws, right? But I think we can all agree that stricter laws have not essentially worked in India, right? The death penalty, for example, doesn't really operate in the rest of the rare cases. If the death penalty did its job of deterrence, we probably wouldn't see the levels of crime we do today. So clearly, punishment is not the only panacea for our evils. It doesn't effectively address some of our problems because it typically addresses the one murderer or the one quote-unquote rapist. It doesn't address the problem of murder and rape collectively. It doesn't address where this comes from. It only addresses the behavior, right? But in a juvenile context, the point that you made is very important because the preliminary assessment to decide whether to transfer the child from the juvenile justice to the adult system is based on three things: mental and physical capacity, ability to understand consequences, and circumstances of the offense. Exactly the point that you made. In that situation, if you don't approach it from a participating framework, which is to listen to what the child has said, how are you expected to then make a decision that actually looks at the adolescent's capacity to commit that crime? And sometimes the system can be hypocritical, right? Because on one hand, we say that no adolescent has the capacity to provide sexual consent under the age of 18, but then we also say that some 16 to 18-year-olds can commit offenses like adults. We have to make up our minds. You have to pick one lane and stick with it. You can't have it both ways, right? So in that context, how do you come to a determination in a procedure that effectively makes an objective evaluation, which is that children don't have the capacity, a subjective one, where some children may have the capacity? What role can participation play in that procedure? It can play a role, because if you listen to the child's perspective, apart from just listening to them, you also conduct objective evaluations that look at their understanding of consequences, their understanding of the circumstances. You might arrive at some kind of reasonably logical assessment of what the child knew at the time of the offense, not what the child knows now after spending 5 months in a childcare institution where they've already received some kind of rehabilitation, which is also again the other issue. How do you get an understanding of what the child's mind was like, say, 1 year ago, 1.5 years ago, after the child has spent a lot of time in the children's care institution? You can't, right? So there's that issue as well. So participation operates. It has implications in any number of contexts. And so if you broadly said, okay, Saurabh, you've been rambling on about participation, what are you getting at? What does justice mean to a child? My answer might be this, that some of you, have any of you ever come across in general reading or otherwise Professor Amartya Sen's framework on the capability approach? Right, I see one person, 2 people, okay, a few of you have. It's a very interesting approach. The idea of the capability approach is not complex, it's very simple. It is very relevant in many different domains, in economics, for example, the Human Development Index takes from this approach. It's relevant in many other contexts. It is also, however, relevant to the question of justice. Now, Sen's approach, the capability approach, is very simple. It says that humans have certain capabilities to achieve certain functionings. Functionings are the beings or doings that we want to achieve. I want to be a lawyer, I want to be a successful lawyer, I want to buy property at some point, I want to retire with a decent amount of money to have a family, so on and so forth. Those are all things I want to achieve, those are functionings that I want to get to eventually. Capabilities are the freedoms and opportunities that I have right now to realize those functionings. Right? So what are the freedoms and opportunities I have right now? So Sen's idea is that based on the freedoms and ideas, freedoms and opportunities that I have right now to achieve a functioning that I value. You may not value it, but I value it. I want to be raising chickens on a farm. For me, that is a valued functioning. You may not find that interesting, but I should have the freedom and opportunity to pursue that. Right? So that's the capability approach. There's no objective determination of resources, but rather the focus of that approach is on what freedoms and opportunities does a person have to develop to reach what they consider to be a valuable goal. Right? And that has implications for what we're discussing right now, which is this question of justice. Right? One, what would be a valued functioning in the context of children in the justice system? If I asked you what a child's objective would be in the justice system, what would some of their objectives be? What would they want out of the justice system? Any ideas? Put yourself in their shoes, think about it. What would you want if you were a child in the justice system? As a goal, I think some of them you've already mentioned. You want a second chance, you want rehabilitation, right? Maybe you might want to be treated well, treated comfortably, not made to feel terrified and scared of being in a courtroom.
Support from the justice system, sir.
Okay, what kind of support?
Monetary support or training or anything that can help the child to grow.
Interesting point. Say I come from, I'm going to give you an example, okay, just stick with me on that point. I am 14 years of age. I have 2 sisters. I live in a very impoverished rural context, right? Both my sisters are farm laborers. I used to go to school, but the teacher, classmates made fun of me because my father has schizophrenia. And the teacher would regularly hit me, corporal punishment, regularly beat me up. And one fine day I decided I could not stay in school, so I dropped out. I came home. My mother, who is essentially the sole breadwinner now because my father has a mental illness, has said that you need to earn money for the family. And so I say, okay, I'm going to try my best to earn money. I'm from UP, but I say I'm going to go closer to Delhi to get better paying work. And so I start working at a dhaba, right? I start making a little bit of money. Every month I call home. I try to send as much money as I can back home, and my sisters and my mom are doing better. Eventually, I get tired of being in this dhaba. I leave. I go to a transport, bus service basically, and start working as a conductor. I make few friends there. They're 2 or 3 years older than me, and they start showing me pornographic videos, right? And they say that if you don't really know anything about this, you can't be a real man. You're just a child, you're a bacha, you don't know all of this, what are you doing? You're just a boy, you know, all of that. And then one fine day, I see two people in a bus, right? With the group, I severely physically assault one of them, and then we collectively engage in pretty gruesome sexual assault, penetrative sexual assault, rape, group rape, gang rape, whatever word you want to give it. Really. Does this case sound familiar? What case am I talking about? Everybody knows it, right? Now, can you repeat for me what point you just mentioned?
Support monetary support training.
Absolutely. Absolutely. Now, for this juvenile who served as the fulcrum for change in our laws, as hard as it may be, if you can put yourself in that juvenile's shoes before you come to the offense, if you're not comfortable being anywhere associated with the person, that's what I understand. But put yourself in that person's shoes before the offense is committed. Where was the system when I got hit in school? Where was the system where my father had schizophrenia? No monetary support then. Where was the system when both of my sisters were farm laborers, child labor? Where was the system when I was a victim under POCSO? Why? Why would this boy be a victim under POCSO? Pornographic videos. Me being made to watch pornographic videos as a juvenile makes me a victim under the POCSO Act because that constitutes sexual harassment. Being shown pornographic videos. And then there are of course separate offences for being the subject of a pornographic video, but that's separate. Some of you I think are engaging with that in online child sexual abuse material, deep fakes, AI, so on. That's a whole other conversation. Healthy interaction was, I didn't know what healthy interpersonal relationships look like. I didn't know what being a man meant, or any of these things, right? Now, in that context, the point that he's making about supports, what supports does the system need to provide this child if we agree on a simple premise that as far as possible we want to rehabilitate children? Because the alternative is that we don't, and we don't have the prison capacity to keep criminalizing people in that way, because if all these children are not potentially rehabilitable, then we have a serious problem. We don't have the capacity to actually put everyone behind bars, right? So in that situation, rehabilitate. And so if the goal is rehabilitation, what are the opportunities, coming back to the capability approach, that this adolescent will need in order to not just be accountable, but in order to actually severely change their behaviors and potentially be some kind of a contributing member to society? It's a tough question, right? But it is one worth asking. Because if you ask yourself, if there was child labor interventions or education under the Right to Education Act, if there was education-related support for this child, or financial support for the child's family where there's only one earning member through direct cash transfer, so on and so forth, nutrition-related support, his lordship spoke about malnutrition being an issue in this country. Would this child still have come into contact with the law? Would this child have ever met those older adults? Would this child have ever been shown those extremely violent pornographic videos? Would this child have ever been in that position to begin with? It's a question worth asking, right? And that's where we come to, if justice is to be with children, as opposed to just justice for children, then that implies that we need to consult them. And each and every one of these hard cases, as difficult as it may be, still requires us to engage with children, because then we get closer to an equitable outcome. That's not just beneficial to child rights activists, who all of us may not care about, but it's also relevant to the state's perspective. We'd written about this through SAMVAD. We'd done a review of literature on juvenile justice, and we found something interesting, which is that criminal or punitive systems don't have much success in limiting crime. If the state's objective is to actually limit crime, we're not doing a particularly great job of it. But rehabilitative systems have shown potential because they actually change behaviors. And if you change behaviors, you can limit crime, because you're changing the root cause of where those behaviors come from. Right? So that's justice with children. That's the participatory framework. And it's worth thinking about, because a lot of you are doing research on the Juvenile Justice Act, on POCSO, on custody, on trafficking, on any number of these areas. It's important to ask some of these questions to really know how to move forward. And that's what his lordship spoke about. How do we move forward? The way forward is perhaps to find scientific ways of negotiating the issues between protection, other social interests like crime, law and order, so on, and participation. They all have to be viewed together. I've already spoken about this, but very briefly, from a child, if you look at two contexts, the child, victim, witness, the objectives of the valid functionings would be harm mitigation. I don't want to be subject to abuse anymore. Restoration, I want to be restored from the harm that's been caused to me through compensation, through mental health services, trauma-informed care, rehabilitation. And through reintegration, I want to go back without the fear of stigma, without suffering any consequences for being the victim or the survivor. I've not done anything, why should I suffer the consequences, right? And from an offender's point of view, you'll have already discussed this. Behavior change, restoration again, that I want to be restored from being in this position where circumstances make me vulnerable to committing this crime. And maybe reintegration, but reintegration in the context of an offender can look very different. For example, in the Nirbhaya case, the juvenile's identity was changed, name was changed, and he was sent to a different part of the country because obviously there were security concerns, right? So reintegration can look like many different things. Now, I wanted to focus on this concept. It's closely tied to this idea of capabilities, of freedoms and opportunities. It's the idea of handicaps, right? That in reality, Amartya Sen posits the argument that there are capability handicaps. There are barriers to realizing these freedom and opportunities, and they're pretty straightforward in a child context. If you look at the justice system, they typically extend to inadequate legal representation. We know that children more often than not don't get adequate legal representation. Even when they do, the system can be quite tough. There was the Ryan International School case, which some of you might have heard, right, which is a murder that took place in a school. It went up all the way to the Supreme Court, which resulted in the judgment in the case of Barun Chandra Thakur versus Master Bholu in 2022. And SAMVAD's assessment methodology was discussed in the judgment because we tried to approach this from a rehabilitative standpoint, right? And what we found in that case was that there were multiple legal lapses. For example, documentation pertaining to the child's case, the complaint, the FIR, the final charge sheet, everything, had been withheld from the child's counsel till 30 minutes or so before the hearing on the basis that this is to protect confidentiality, right? Now this went up to the Supreme Court and the Supreme Court said, this is unbelievable, this is a travesty of justice. You can't use confidentiality to not provide the basic documentation to counsel that is critical to their own legal representation. But all this happened because the child involved in the Ryan School case came from a relatively privileged section of society and could afford good legal representation that could take this all the way to the Supreme Court. What happens to a child who can't take this all the way to the Supreme Court? How many people in this country really have the financial wherewithal to take cases in appeal for years together, right? So in that situation, would that be a handicap for this particular child, affecting their freedom to exercise their due process rights, opportunity to have a fair trial, fair hearing? Adult-centric legal processes, we've discussed some of this. Lack of age and developmentally appropriate support. I'll come to this when we discuss POCSO a little more, right? Lack of access to rehabilitation. Now, the interesting thing about child rights, and this is true for every single one of your papers, is that child rights, unlike most other areas of rights, whether it's socio-economic rights or general civil and political rights, or say, other contexts, disability rights, is that child rights doesn't involve just two stakeholders. Most rights-based conventions or systems involve the state and the person. That's effectively the relationship. But child rights is complicated because you also have the parents and the family involved. There are three stakeholders that are involved. And so, if you triangulate these three stakeholders, how do you ensure that the ultimate decision that is made incorporates all three of these: participation, protection, best interest? Because you have three stakeholders and you have multiple competing considerations sometimes. It's not easy, right? And it will depend on the case relationship, or we're speaking about transfer from the juvenile justice system to the adult system, it varies. But the basic premise is that there needs to be more scientific ways to approach this so that you take into consideration all these stakeholders and you have a process that doesn't exclude or make decisions that are actually not in the child's best interest. Right? Now this is very briefly, I don't want to spend too much time on this, I'm sure some of you have already seen it. But Article 12 of the UNCRC, which deals with the right to participation, which is what I have been speaking to you about today, has certain key pointers, right? One of them is that a child who should be capable of forming his or her own views, which is a question of capacity. Which child is capable of forming their views? That's a case-to-case determination. To express those child, which I spoke to you about previously, with due weight given in accordance with their age and maturity, which is again a difficult provision. How much, how do we determine maturity for in a judicial hearing, say, right? And this applies, of course, to judicial and administrative proceedings, and multiple other aspects of this. But generally, the idea is that this is a bit difficult, right? Because maturity evaluations become important, like Section 15 of the Juvenile Justice Act that I spoke about. It also becomes important if you're a victim or a witness or a victim witness in a POCSO case. Competency of a witness under what used to be Section 118 of the Evidence Act, now it's different, I think Section 123 under the BSA, that looks at competence of witness. That basically you should be able to understand the questions put to you and you should be able to respond to the questions coherently, right? And that you should not be affected by the access tender years or so on, but the idea being you should not be affected by immaturity. Now, deciding which witness is capable of understanding and responding to questions, again, is a very subjective assessment. And arguably not within the professional competence of a judicial officer, because that's not a legal question. That is effectively a question from child development or mental health, so on, right? But it is the judicial officer's role in that situation to make this determination. And judicial officers, to the best of their ability, try to incorporate children a lot of the time. But what happens when it's hard for us to look at a witness's competence because we don't know what to look for? How do you say a child is able to understand the questions and respond to it if the questions themselves are adult-centric questions, or the questions are posed in very complicated ways, right? What are the key competencies that a child needs to be an effective witness? Child needs to be able to recall incidents, memory. Child needs to have some amount of descriptive ability, right? Child needs to be able to understand the questions being put to them, right? Child needs to be able to reasonably provide coherent evidence. All of these are again subject to the specific social and cultural context that children come from, right? Coming back to the question of sexuality and the issue of providing sex education in this country. It doesn't just affect consensual relationships, it also affects questions of abuse. Because from a young age, typically, and a lot of us know this has been most of our childhoods as well, typically children are not taught to be able to identify their body parts properly. We have colloquialized words like nunu or whatever to describe genitalia, but we're not taught to label them properly. Because from a young age you're told, shame, the body typically is something that nudity or any sort of aspect related to anything that could even be remotely construed as sexual is something that you're not taught to speak about. Now, what happens when that child is subject to, say, a sexual offense and has to provide evidence? The child maybe has enough memory recall, the child maybe has enough wherewithal to describe the incident, but the child may not have the language. This happened in a case where someone I know very well was deposing as an expert witness, as a mental health professional. And in that case, the child had mentioned that he put his snake in me. It was a case of penetrative sexual assault. The child said that he put his snake in me. The snake came from a bush. Now, that was not sufficiently clarified in the report that went to the court. And because that was not clarified, the defense counsel had a field day. all they had to say was that this child is prone to imagination, this child is an unreliable witness, this child doesn't have the competence. Now, in the absence of evidence to suggest that the child did in fact have competence, and in the absence of a lawyer who should have asked a follow-up question to say, where was the snake? Where did the snake come from? Where was this bush? To just ask the questions necessary that would have made the point that this child was referring to this person's genitalia. But the questions were not asked, the child was perceived to not have competence, and the case ultimately did not result in a conviction. So these things matter. How we define competence matters, right? And that has to be child-centric. You cannot expect a child to have the correct legal language in a country where we don't teach children to say anything about sex. The word sex itself raises alarm bells most of the time when we hear it in a public environment, right? So in that context, how do we expect children to have the perfect language to describe body parts when we don't teach them at home? Where sex education, or more than sex education, the first step to sex education is just personal safety awareness, is not provided as it should be, right? So again, questions worth considering. Now, very briefly coming to the scope of this right, and I'll come back to our discussions on Indian laws. The idea is that the right to participation should be respected at every stage of any proceeding, right? And for a child, in conflict with the law, information is one of the key aspects of child participation. So if a child doesn't know that the juvenile justice process is fundamentally different from a criminal trial, the child cannot effectively participate. If the child is not made aware when court hearings are supposed to happen, what each court hearing is for, how decisions on bail are going to be made, then the child cannot effectively participate. If the decision on bail being made is not made in accordance with the Juvenile Justice Act, but is made in accordance with the CRPC or the BNSS, then the child cannot effectively participate. Right? There are multiple contentions involved, but the idea is that the child needs information, the child support system or family need information. Without that, there's no question of participation. And it should be conducted in an enabling atmosphere. Right? One of the most difficult aspects of juvenile justice administration in this country is that judges are heavily overworked. Right? And juvenile continuously only with regard to juvenile matters. Magistrates, principal magistrates typically sit a few times a week in most states in the country where they have many other responsibilities for the remaining period. So it's very hard to expect them to shift orientation constantly from normal adult cases to child-centric cases. It's not an easy task. I don't think many of us would be very successful at it either, because it's an extremely difficult job. Right? So in that situation, how feasible is it to really create an enabling environment? Again, as is my job today, I can't provide you easy answers, but it's just more for you to think about, right? The answers may be that we should have special judges that, or at a magistrate level, who only focus on juvenile matters. But then again, you'll run into many administrative issues, which is that different kinds of matters usually convey different levels of seniority and have different administrative performance-related issues attached to them. If you speak to most family court judges, they'll honestly tell you that family court judges in most parts of the countries is perceived to be a punishment posting. So there are administrative issues as well, right? So how does that subsequently impact the actual administration of justice? How does it actually inform what the enabling environment of the law is? We come back to the point that His Lordship raised, which is that, there are these problems, but how do we actually realize the noble aims of our law? How do we in practice implement some of these things when we have many challenges? Right? So this again is in the context of child victims and witnesses. It's similar to participation for a child in conflict with the law. The primary distinction, and this is basically the general comments that you can see here, are the documents generated by the Committee on the Rights of the Child, the treaty monitoring body for the UNCRC, and they are relevant in how we interpret these rights in India as well, because the Juvenile Justice Act explicitly refers to the UNCRC, right? Now, in the context of a child witness, this could include a number of things. That they need to be provided information pertaining to health-related services, how questioning is going to be conducted. If a child is not prepared for what cross-examination is going to look like, how is the child expected to be, a reasonable witness? Now, again, I'll actually, let me move forward with that, and we'll come back to this. The POCSO Act, right? Yeah. The POCSO Act are called the vulnerable witness deposition complexes that are being set up pursuant to Supreme Court order, where children are required to be kept in a separate room. They're not even supposed to be in the same room as the accused. The judge sits in a separate room. It's all done through video conference. Right? Now, in this context, the question is supposed to be put to the judge, and that they're supposed to be relayed to the child. That's easier said than done, because the art of cross-examination, unlike chief examination, is reliant on how the child answers. It's responsive to what the child says. So you can't really provide a completely prepared list of questions beforehand. So ultimately, in most situations, what happens is that judges will allow defense lawyers to pose questions directly, and they will stop them if they feel that the question is inappropriate to the child. So again, this comes back to implementation, right? We have these broad noble aims, but if the law is not in consonance with practice, how do you realistically look at some of this? And you can't do away with cross-examination of POCSO case, because that's the very core of the right to defense, of course. It is an integral part. But broadly, what I want to essentially convey is that all of these considerations ultimately rely on not just providing an opportunity for participation, but providing scientific ways of incorporating the participation. Participation has to be reliant on how the assessment is conducted. What does available scientific literature say about how evidence is supposed to be taken? Right? What does literature say about how children are supposed to be spoken? What does literature say about how forensic interviewing is supposed to be conducted? There is information available on different aspects of child rights in practice, but the question is, how do we incorporate that to facilitate age and developmentally appropriate participation, right? And so ultimately, we come back to the same tension, right, between protection and participation. How do you negotiate some of this? I don't know, the answers are not easy, but a lot of you have written papers today, so maybe you'll be able to provide us with answers that deal with some of these issues. But the idea is that we need to stay within the realm of more objective assessments than given to subjectivities, because that's where the problem really comes. When there is too much discretion and there's not enough material available for how we objectively do certain things. How do you objectively evaluate child competence? How do you objectively evaluate quote-unquote maturity, which is, all of these things. So, yeah, that's about it from me. Do any of you have questions, or if you wanted to discuss anything?
I want to ask something.
Yes.
So, we were talking about a case where the mindset of a child, while he was dropping out from the school, where is the system? And then when he is working, so what I'm trying to ask is, if a state, so what should be done by the state according to you to prevent this? So before he committed the actual offence, that's where the system has come into picture, and we are asking the child, what is your consequence, whatever you are dealing with the judge. Then before this, there are many laws, right? In our system, we have the right to education, and we have so many CWC.
That's an interesting question. I think the short answer is that the difference, if you look at the social investigation reports, child protection, there's usually a social investigation report prepared, which has information about their family circumstances, schooling history, child labor experiences, various other factors, right? The difference between a child in conflict with the law and a child in need of care and protection ultimately is in how they came into the system. But if you look at their social investigation reports, there's not that much of a difference in terms of how they're vulnerable. Now the question is, if a child in need of care and protection is assisted by the system before they come into conflict with the law, then they enter the system as a CNCP. But if you wait till an offence is committed because services are not provided, then they come into conflict with the law. But specifically, if you look at what that means, right? That means that children need to be actually assisted where it is important. Now, child labor cases, a lot of states have state-level child labor task forces, right, which typically involve some of the highest functionaries in the state and at the district level as well. How many rescue operations are actually being conducted, right? How many we have the fund that has been established on the basis of, which is levied against child labor employers. How much money does this fund actually have right now? How many cases have we actually seen where rescues have been conducted? Right? Child marriage cases. Every district magistrate and sub-divisional magistrate is a child marriage prohibition officer under the Child Marriage Act. There was a research done a few years ago that looked at who was basically filing cases. Almost no cases were filed by the child marriage prohibition officers. Majority of the cases were filed by parents against children who had run away and gotten married. But parents who were themselves marrying the children off, almost no cases were filed against. The Child Marriage Act says that there are certain days in the year where there are more child marriages likely to happen. How many rescues and how many injunctions are filed in court before that? Because under the Child Marriage Act, you can file an injunction to stop a child marriage. How many injunctions are filed? Right? The question is, if you don't trigger the application of these child protection laws, then you reach a situation where a child is likely to come into conflict with the law. And then we get stuck with the problem where we have to deal with crimes which cause harm to not just that child, but harm to society. Right?
So, will I be right if I say that if I identify who is the child or children in need of care, the first step where I say that this is the list, who is the dropped out from the school, maybe they are like below the poverty line. If I'm able to identify as a state that these are the vulnerable kids who may later on come to the system as offenders, maybe they get exploited, maybe they are victims later. So do I stop them at that stage if I'm able to first identify them?
Absolutely. Right? And we saw some of this take place during the COVID crisis as well. There was this portal set up by the government. There are issues always in implementation, but there were teams that were sent out to really do a mapping and find these children and bring them within the fold. There's a petition, ongoing petition before the Karnataka High Court as well, that looks at street children. How to map street children, how to rescue them, how to rehabilitate them, how to provide access to education services, so on and so forth, right? So these kind of initiatives, mapping street children, all of these kind of initiatives that essentially prevent, looking at COVID offers, things that are rooted in the idea of prevention will ultimately be the best.
Having any laws for prevention? We have laws after what offense happens, right?
Yeah.
So we have all these juvenile justice systems, everything to take care of children once an offense is committed.
Yeah.
But do we have law for prevention?
These are your prevention laws. Child protection laws are your prevention laws. The question is, when do you activate them? And to what extent are they actually implemented?
There's no trigger point is what you're saying.
Because the cases are not brought,
So
the cases are not implemented.
cases
Right?
being brought or proactively state interfering, I will go and find out.
It's a mix of both, right? It's a mix of schemes and it's a mix of implementation of the laws. So ultimately, it's a question of both. Right?
What about the recruitment and use of the children in the armed conflict?
In armed conflict?
Like recently, even in the Ukraine and the Gaza war, many of the children's rights have been violated, and people have been trying to use the children in the armed conflict. So, would you please put some light on that so that we have some insight from the
yeah, armed conflict is interesting. Armed conflict brings in a whole bunch of other laws, and I'm pretty sure we're out of time, so I won't spend too much time going into that. But that's typically a mix of international humanitarian law and human rights law, right? The basic premise is that child rights will apply even in times of armed conflict. Human rights is not suspended in times of armed conflict. If you talk about recruitment of child soldiers or use of children as human shields, of course they violate the Geneva Conventions, plain and simple, right? Begins with that. You can't intentionally use civilians who are non-combatants in a situation of armed conflict because that goes against the Geneva Conventions. Recruitment of child soldiers, the Child Rights Convention says age of 16, and the optional protocol on children in armed conflict to the Child Rights Convention says 18, right? But even for a child as young as 16, it's supposed to be voluntary recruitment, so on and so forth. But the idea is that you shouldn't ideally have recruitment of child soldiers. Now, all of this exists in international law. I won't go into too much specifics. So you have the Geneva Conventions, you have the Child Rights Convention, you have the optional protocol on the Child Rights Convention on children in armed conflict. But international law is difficult to implement, right? And especially in India. India is a famously, largely dualist country. We don't directly incorporate international law. Even legislation like the Juvenile Justice Act that rely on international law, they only, it's only implementable in India when it's passed as a legislation in India. So the Juvenile Justice Act is arguably an Article 2153 legislation to implement international treaty. right, that incorporates UNCRC prerogatives. But India would not, you can't hold the state accountable for violations of international law without there being a domestic legislation in India. So there are multiple issues. There's also the issue in some of the conflicts you mentioned, like for example, the International Criminal Court, the Rome Statute has only been signed by a handful of countries. It's not been signed by many countries. The International Criminal Court says they have jurisdiction in Palestine because Palestine signed the convention. But Israel is not going to heed, right? Israel is not going to say, yes, please come and investigate my country. There is an ongoing genocide right now. There is huge casualties. Every day we see casualties. So in armed conflict, the question is, how can you pursue domestic measures that are effective? Because international measures will always be restricted, right? In India as well, we have had skirmishes, right? We saw, for example, the tensions in Manipur relatively recently, where there was a conflict, right? So the question there is a concern that children are getting involved in conflict. So how do you then mitigate some of that? It's a difficult question.
And children have nothing to do with the war which is being between two states. So even their lives are being violated. So
yeah, but that's the question, right? That's the idea that child rights doesn't operate in a vacuum. Child rights operates in relation to humanitarian law, in relation to what the state's objectives are, so on and so forth. The question is, can you leverage international law for primarily in an advocacy capacity because that's where it's effective, and can you use domestic remedies to the best extent possible? So if there is a armed conflict hypothetically in India where you want to intervene to protect children, your best bet will obviously be to use laws that are applicable in India. For example, the Juvenile Justice Act explicitly references armed forces. It would apply to armed forces. The POCSO Act references armed forces, so it would apply to armed forces. Right? So you try to see what are the domestic remedies available in any of these contexts and see how far they're implemented. The problem in, say, a context like Palestine is that the domestic remedies are effectively not available because it's an occupied territory. Right? So in that context, apart from international law, the law is not limited. How much can it really do?
It's regarding the same question that you had raised about the Palestinian or the kids dying over there. If we can't save them through the international conventions or some other international laws, then what is the use of these laws? Is it just written on the papers? Because in real time we can't use it. So what is the actual use?
That's a good question, and maybe the oldest question that's ever been asked for international law. How useful is it? Some legal scholars will say it's not even law, it's positive morality, right? That's a separate conversation. But the idea is that I think these things do matter. I think cumulatively they do, in hindsight, move just a little bit towards mitigating the conflict. For example, South Africa filed the case before the International Court of Justice alleging genocide, right? The International Court of Justice then issued a preliminary opinion saying that there is prima facie evidence that a genocide may have happened. It's still not provided its final opinion, this is just a preliminary opinion, but the fact that they admit that there is a possibility of genocide means that other countries in the world can use that as a legitimate argument to say that Israel is likely committing a crime of genocide in Palestine right now. Without that, you don't have the capacity to even say that. Without that, it becomes a question of he said, she said, different people saying different things. But when you have an international opinion of that sort, it carries some weight. I know it doesn't go far enough. It doesn't go far enough in terms of being able to stop the conflict, but it provides countries that care about international law. It often does come too late, but at least if it comes, you have enough legal standing to say that we did all of these things. And legally speaking, countries now have some ability to say, not just on the basis of the ICJ opinion, but you have the special rapporteurs. You have the special rapporteur on Palestine, Francesca Albanese. Strongly recommend reading her report. She's done extensive work on exactly what violations have occurred in the occupied Palestinian territories. You have multiple people who've already said, right, what every international expert affiliated with the UN has made the claim, every international organization, NGOs have made the claim that there are violations happening, which just makes it harder for them, the Israeli state to then respond and say we're actually just defending ourselves, or that children are present in places where there are Hamas terrorists and therefore there's a need to carpet bomb multiple areas in Palestine. These arguments become less credible because there is international law galvanized against what is effectively violent state actions, right? So it is useful, but I share your disappointment in terms of it not being far enough. But that is the system we have, right? There's no, we can't, if that is the system we have, we can just see how best to navigate it. There's nothing else we can do. Right? I think that's about it. Thank you so much.